It was the first plenary of the week with a busy order paper. Prominent among the items for consideration was the report on the amendment of the Criminal Code Act Chapter 38 of 2004, which seeks life imprisonment for kidnapping. The bill also seeks to redefine the concept of rape to include males and to delete statute of limitations on defilement.
Mr. President, I move that the Senate do consider the report of the Committee on Judiciary, Human Rights and Legal Matters on the Criminal Code Act, Cap C 38, Laws of the Federation of Nigeria 2004, Amendment Bill 2020. Mr. President, I so move.
Senator Surajuddin.
I rise to second the motion ably moved by the Chairman, Committee on the Judiciary, Human Rights and Legal Matters, Senator Okoyemi Bamidele, Central. Thank you.
The motion moved by Senator Bamidele Okoyemi Michael that the Senate considers the report of its committee. Say aye. Those against say nay. The ayes have it. Senator Bamidele, you can present your report.
A bill for an act to amend the Criminal Code Act Cap C 38, Laws of the Federation of Nigeria 2004, to delete the statute of limitation on defilement and increase punishment for the offense of kidnapping, remove gender restrictions in the offense of rape, and for related matters. The Criminal Code Act Cap C 38 Laws of the Federation of Nigeria 2004 Amendment Bill 2019 was sponsored by distinguished Senator Oluremi Tinubu, representing Lagos Central Senatorial District. The bill was read for the first time on Tuesday, 24th September 2019. On Tuesday, 26 November 2019, the Senate deliberated on the general principles of the bill. After extensive debate, it was read the second time and referred to the Senate Committee on Judiciary, Human Rights and Legal Matters for further legislative action. Vide order of referral dated Tuesday, 26 November 2019 to report back with its recommendations. After the referral, Mr. President, the committee held a series of meetings and agreed on the following legislative framework: to consult widely and seek views of stakeholders on the justification for the passage of the bill, and to resort to any other matter incidental thereto, which would assist the committee in the discharge of its assignment. Mr. President, distinguished colleagues, the objectives of the bill, among others, are to delete the statute of limitation on defilement in sections 218 and 221 of the Criminal Code Act, Cap C 38, Laws of the Federation of Nigeria 2004, and amend the definition of rape in section 357, as well as provide stringent punishment for the offense of kidnapping in section 364 of the Criminal Code Act. In furtherance of this assignment, the committee relied on the legislative framework earlier agreed upon as the way forward. Accordingly, in addition to the wide consultations that were made with relevant stakeholders in order to elicit their inputs on the proposed legislation, the committee also considered divergent views expressed by distinguished senators on the merits of the bill during the second reading stage. Mr. President, distinguished colleagues, I wish to state here for the avoidance of doubt that from views expressed on the bill, there were opposing arguments on the passage of the bill by the National Assembly. It will interest distinguished senators to know that the committee scrutinized in detail all the views canvassed for and against the passage of the bill, taking into account extant laws on the subject matter. Below are the highlights of the views expressed by stakeholders on the proposed legislation, both for and against. Mr. President, with your permission, I will skip that, since we all have copies of this report, to page 6, where we talk about observations and findings of the committee. Flowing from the analysis of submissions made by the stakeholders on the bill, and based on our subsequent consideration of the bill in our markup session, the committee hereby makes the following observations and findings. 1, that the introduction of the bill is laudable and commendable, as its passage into law will address the lingering issues of statute of limitation in the prosecution of rape as well as defilement cases and the incessant kidnapping menace which are on the rise in recent times. 2, that even though statute of limitation has been deliberately omitted from the Violence Against Persons Act 2015, which is the prevailing law on the subject matter, intended to give room for prosecution of offenses of this nature, it is not of general application. As such, this proposed amendment is a welcome development. 3, that by virtue of Section 315 of the Constitution of the Federal Republic of Nigeria 1999 as amended, dealing with savings and transitional provision, the National Assembly has the legislative competence to amend the Criminal Code Act as an act of the National Assembly by its virtue of being an existing law. 4, that the National Assembly can amend the Criminal Code Act in line with the aforesaid provision, which gives it power to take over all existing laws made prior to its existence and subject such laws to necessary modifications in order to bring them into conformity with the Constitution. 5, that contrary to views canvassed by those opposing the passage of the bill by the National Assembly, on the ground that its passage will usurp the powers of the state to legislate on the subject matter, it should be stated, for the avoidance of doubt, that the proposed bill seeks to amend the Criminal Code Act of 1916 and not Criminal Code Law of the states. And finally, that the bill, when enacted, will apply to the federal high courts in the southern part of the country where the Criminal Code Act is applicable and operational. Recommendation. The Senate Committee on Judiciary, Human Rights and Legal Matters, to which this bill was referred, having considered same, recommends as follows: that the Senate do pass the Criminal Code Act Cap C-38 Laws of the Federation of Nigeria 2004 Amendment Bill 2020 as amended. We so move, Mr. President. And Mr.
Any comments? Leader of the Senate.
I think it's important for members who know the law, and there are many of them in this great chamber, to really explain this issue, particularly paragraph 5, number 3, 4, and 5 on page 6. That is whether the National Assembly is competent to make laws regarding the criminal and penal codes, which are the responsibilities to me of state legislators, and whether we are not going to be constrained by what happened to the Child Rights Act, which the Supreme Court later interpreted, after we finished the law, to apply only to the Federal Capital Territory. I think these are important issues that we need to clear, before going into the real nitty-gritty, of the law that we are about to enact.
Those in favor that clause 28 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 29 on page 62.
Thank you for joining us on the live broadcast of Senate plenary today, Wednesday, the 22nd of July, 2020. Well, the Senate has reconvened for today's plenary. So far, it has passed 5 bills for first reading, This includes the Institute of Information and Communication Technology, Iwo Osun State Establishment Bill. And at the moment, the Senate is considering the Bank and Financial Institutions Amendment Bill, which is still ongoing. That amendment started yesterday, but there were some differences that needed reconciliation, and the Senate had to step it down for today's consideration. And that is what is ongoing at the moment. I am Ignatius Nkwo.
32. Clause 32, those in favor that clause 32 stands part of the bill, say aye. Those against, say nay, the ayes have it. Clause 33, those in favor that clause 33 stands part of the bill, say aye. Those against, say nay, the ayes have it. Clause 34, clause 34, those in favor that clause 34 stands part of the bill, say aye. Those against, say nay, the ayes have it. Clause 35. Clause 35 is deleted. Those in favor that clause 35 stands part of the bill, say aye. Those against, say nay, the ayes have it. Clause 36 on page 78 deleted. Those in favor that clause 36 stands part of the bill, say aye. Those against, say nay. The ayes have it. 37 deleted. Those in favor that clause 37 stands part of the bill, say aye. Those against, say nay. The ayes have it. Those in favor that clause 38 on page 84. Clause 38 on page 84. Those in favor that clause 38 stands part of the bill, say aye. Those against, say nay. Page 80. Oh, okay. That's correct. That's the new 35. So those in favor that the new 35, clause 35 stands part of the bill, say aye. That's page 80. Those against, say nay. Ayes have it. Clause 36, the same page. Those in favor that clause 36 stands part of the bill, say aye. Those against, say nay. The ayes have it. Clause 37 on page 82. Those in favor that clause 37 stands part of the bill, say aye. Those against, say nay. The ayes have it. Clause 38 on page 84. 38 on page 84. Those in favor that clause 38 stands part of the bill, say aye. Those against, say nay. The ayes have it. Clause 39 on page 88. 39. DSP.
Thank you, Mr. President. 39. I don't know if, let me read. Say subject to any other provisions of this act. All claims, judgment, debt enforcement. I think it should be judgment, debt enforcement, I believe. In which case that comma should be removed. So it should be judgment, debt enforcement.
That comma should not be there.
Chairman, have you listened to the DSP? Is that correct? Judgment, debt enforcement. So the comma should be deleted. The comma. Only the comma. Those in favor that clause 39 stands part of the bill, say aye. Those against, say nay. The ayes have it. Clause 40 on page 92. Clause 40 on page 92. Those in favor that clause 40 stands part of the bill, say aye. Those against, say nay. The ayes have it. Clause 41 on page 95. 41 on page 95. Those in favor that clause 41 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 42 on page 97. Those in favor that clause 42 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 43 on page 98. Those in favor that clause 43 stands part of the bill say aye. Those against say nay, the ayes have it. A new 39. No, that's deleted. Okay, there's a new 43 on page 99. The new 43 is on page 99. Those in favor that clause 43 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 44 is on page 101. Those in favor that clause 44 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 45 on page 104. Those in favor that clause 45 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 46 on page 105. Those in favor that clause 46 stands part of the bill say aye. Sorry? 45. Those, sorry? Clause 46. Clause 46 on page 105. Those in favor that clause 46 stands part of the bill say aye. Those against say nay, the ayes have it. Yes, Senator Balanala.
Mr. President, sorry to take you back. I am not as fast as you can go. Section 40, clause 43, sir, appears to be in contravention of the Constitution of the Federal Republic of Nigeria, sir. Not. No, it's a new 43. Yes. Page 99. At page 99. The new 43. Yes, sir. It says, except with the written consent of the governor, no bank shall be registered or incorporated with a tribal or ethnic name or any name which includes the word central, federal, federation, national, Nigeria, reserve, state, Christian, Islamic, Muslim, Quranic, or biblical. This will clearly violate the provision of the Constitution, sir, because in the Constitution, sir, any person can come together for the purpose of fostering an economic agenda. And if, for example, it's the decision of the Christian Association of Nigeria to build a bank for the benefit of their people, that is expected to be allowed, because first, the Constitution gave them right to practice their religion, unhindered. So I think we have to be a bit careful about this, because it's unconstitutional, sir. That's my fear.
Senator Ibikunle Amosun.
Thank you, Mr. President. Ibikunle Amosun, I represent Ogun Central. Distinguished colleagues, yes, without prejudice to what Senator Nala said, drawing our attention to this, I think there is no way we can write everything out like this.
Yes, it is written. But since that proviso is there, that except with the recent consent of the governor, it is just to make sure that people do not abuse this. That is what I think. Because they are not saying they cannot, but they are saying that they probably need the consent of the governor so that decorum will be maintained. You know the way we are. You can, yes, I agree with you. You can have Christian whatever bank. You can have even Ijo whatever bank. But the some may be such that the governor we want to advise. I don't think there's anything wrong with this because they are not saying they cannot. So to be a bit cautious, sir. Oh, okay.
Well, Mr. President, my highly respected and distinguished colleagues, on this particular issue, I think I really concur with I do understand the position of Senator Balana Allah, but I think the word except, so I do respect the position of Balana Allah, but I do concur with the position of Senator Ebukule Amosu. Given the nature of this country, the frivolous usage of some of these very loaded terms, if they are not checked, could bring us into a lot of unnecessary conflicts. So I think this clause was inserted so that the central bank governor can be able to advise and to be able to actually notify the kind of intendment of those who are promoting this business. So that if there is no problem of taking those names, he will just say, okay. But if he senses that there are certain kinds of issues, behind the usage of those terms, he could now say that you have to expulge, that particular term you have to be registered. So I think it's to err on the side of caution, and therefore I really support the position of Senator Amosun without really dismissing the constitutional issues that have been raised by Senator Balana Allah.
It is one thing for an act to be constitutional or not constitutional. It is another thing to subject the fundamental rights of citizens to a discretionary exercise of power by an individual. This is the caution that I'm trying to draw. It is even more serious, Mr. President, when we consider the unique nature of the Federal Republic of Nigeria. If tomorrow, God forbid, they say distinguished Senator Ojikalu is the central bank governor, and then I apply, I apply to register a bank in the name of, let's say, Islamic Bank or something, and in his opinion, it does not work, and then he says, I'm not going to grant the consent. Meanings will be read to it. So that's why nowhere will a fundamental right, nowhere will a fundamental right of a citizen be subjected to the discretionary exercise of an individual. That's the only thing. And I still maintain my position that this provision is unnecessary. The consent to register a bank is entirely that of the central bank governor. There is no need to put this as a cobweb for him to hang him to the exercise of power when we know ab initio it is unconstitutional. I will seriously and respectfully advise that the provision itself is even unnecessary, that let it be deleted. Thank you, sir.
I think I will agree to a large extent with submission by Senator Bikule Amosun. Nobody is denied that right. And all that I think the clause intends to achieve is to ensure that there is no frivolities or recklessness in just writing whatever somebody wants. Your argument on the face of it is okay. But if we just allow it like that, probably it will be a subject of litigation unnecessarily, because there will be no provision for anybody to checkmate that possible recklessness that could result. So I would advise that we leave it as it is. And because Parliament will be here, even if we will not be here, if there is any abuse, then Parliament can amend it. Senator Alero.
Thank you, Mr. President. Mr. Chairman, distinguished colleagues. Mr. President, I think it is dangerous to leave it as it is now, because we cannot make law that go against the Constitution. Any law that goes against the Constitution, to the extent of inconsistency, is null and void. That is the position of our Constitution. And there are so many organizations now that are interested in setting up non-interest banking. And if you subject the approval of non-interest banking to a particular individual, Mr. Chairman, it is dangerous. What the Constitution has given you, nobody can take it away from you. So I'm of the opinion that we should delete this section completely.
Thank you, Mr. President. Very distinguished colleague. Mr. President, I follow the discussion with rapt attention. But if you look at it from the two angles, the first one is afraid that why should we give the sole power to a single individual? And the second one is saying it's just as a guide to checkmate. In balancing the two, I'm of the opinion that there is a board of Central Bank of Nigeria where we have people with diverse opinion, diverse mind, that whenever any such thing is put before them, there will be need for them to read through. So we can simply say, except with the written approval of the board of Central Bank, then that will guide. Single individual will have been taken care of. The caution we are trying to draw will have been taken care of. I so submit.
Thank you, Mr. Chairman, distinguished colleagues. Aliu Sabi Abdullahi. I think he has tried to solve the problem so that perhaps the fear is taken care of. But the key issue, I think, from the debate is whether this issue is impinging on some people's right within the consent of the Constitution. To my mind, it is not, because it is not saying absolutely that you cannot. It is rather saying they need to guide. And this becomes necessary if you are following the trend on social media and other media of what is happening, where people will just use this name innocently and just get unsuspecting public to bring in money through the back door, and the central bank has no control over those people. And I think it's very important that we put that at the back of our mind, because many people are losing their money from people who just come out using that name, just what this clause is trying to cure. So I support what Solomon Adeola is saying, because that will also take care of fear people are expressing about who does it.
Well, distinguished colleagues, we have already voted on this, unless you want me to put it to vote again. So, are we taking the amendment of Senator Solomon Adeola? Sorry? No need. No, that is an opinion. So, I will put it to vote again. As someone, no. There is an amendment that is seconded. Those in favor of clause 43 as amended, say aye. Those against, say nay. The ayes have it. Secretariat. Senator Solomon Adeola, you write that amendment properly, please. Just like you have said it. So we go to clause 46 on page 105. Yes. Senator Johnson.
Mr. Chairman, sir, I'm just being curious.
on page 104. On page 104, 45. The extant law is talking about prohibition of strike or pandemic. The extant law, the one that is recommended by the committee, is completely different. Strike is being left out. It's only pandemic or what is included here, strike is left out. I don't know whether somewhere in the bill, the issue of a legitimate strike is part of the reasons why a bank will not be held liable. 45. The strike is not there anymore. I don't know where the strike is somewhere.
Mr. Chairman, where did you hide it?
Chairman, the extant law is the principal. This is talking of during a strike or pandemic, but your recommendation does not include strike.
Which page is that?
Page 104.
What is the recommendation? Comments? Which one? What did you want to conclude?
There should be strike here. Don't put strike here.
Where?
Here.
Yeah, I'm looking at the.
I think we just put strike here. Don't put strike here.
Where is it? From here. 45.
Page 104.
No, I have that.
Oh, yes, it's different.
No, they can include the strike.
They can include the strike.
Mr. President, I think we agree that we can include the strike in the provision. We can include the strike in the funding. Mr. President, I think I've gone through the section, and I think I agree with my colleague we can include the strike there. We can amend it.
We are taking back the strike. So how does it now read? Because we have to have a final position on this. So it means we have to include no. Clause 45(1) will now be: no bank shall incur any liability of any of his customers by reason only of failure on the part of the bank to open for business during a strike. That should be 1. No, the heading can be, yes, just you add the strike. Okay. So Secretariat, take note. I think it's something we have agreed on. They should include the strike. Just like the principal act, closure of a bank during a strike or pandemic. Isn't it? Okay. We are past that. So clause 46, those in favor that clause 46 stands part of the bill, say aye. Those against, say nay. The ayes have it. Yeah. Clause 47. Clause 47 on page 106. Amendment 47.
Mr. Chairman, distinguished colleagues, clause 47, page 107, 47 2D. This section is talking about people who can hold positions in a bank. It's a small amendment I want to make. 2D says, if a convicted person, if convicted of an offense, individual of, yes, of dishonesty, of fraud, 107D, is convicted of any offense
Convicted of what?
involving dishonesty or fraud. I want to add sexual offenses. If you're convicted of sexual offenses, you can't hold a position. The section is talking about those who can hold position in the bank. Yeah. Talking about those who can hold this. It doesn't matter. It's the same thing. The section is talking about disqualification and exclusion of critical individuals for managing a bank. Both men and women.
Okay. No, let's finish with one first. You say for 2D. 2D is convicted of any offense involving dishonesty, fraud, or sexual offenses. Okay. No, just hold on, please. Senator Susan.
Mr. President, why I support the amendment, there's an issue that comes with it, Mr. President. And the issue is that this particular provision is lifted from what is in the Constitution. And in the Constitution, you don't have that of sexual offense. And so, why the amendment here is good, if somebody takes this matter to court and the Constitution comes in as a superior statute, it might be a problem. But the amendment is good if we can take it. But this is lifted from the Constitution. And so that is the only thing that is a snag on this. No, you see.
This offenses register that has been opened, does it mean that that register is of no use?
Distinguished colleagues, I really sympathize with the position our colleague Senator Betty Apiafi has taken. But my understanding of this dishonesty or fraud, these are things that are not required in an environment of trust in terms of banking. So I'm not sure if sexual offense can go in line with this. But can we find Senator Said Al-Ghali?
Mr. Chairman, if she reads Section D, she should go ahead to read Section E. Is guilty of serious misconduct. Is guilty of serious misconduct in relation to his duties. What she is saying is a misconduct, so Section E covers that.
No, Mr. Chairman. Mr. Chairman.
It's a misconduct.
You see, Your Excellency, I can understand what she was trying to say, but we have to understand that sexual harassment or rape or whatever it is, that way is a criminal act. But here we are talking of dishonesty, because when you are talking of banking, you are talking of trust. Trust. That should be the main thrust. But sexual offense cannot be part of this, really. Please, let us be serious.
Thank you very much, Mr. Chairman. The argument so far has already exposed the difficulty that we will get into in accommodating this amendment. Now, if you look at E, Mr. President, E says is guilty of serious misconduct in relation to his duties. In relation to his duties. So there is no relationship between the duties of a banker and sexual offense. So this is not wide enough to cover that misconduct. Fluid as misconduct is in its determination, I'm of the opinion that the position of Senator Susuan stands valid, sir. We might find somewhere to accommodate it maybe, but here it appears almost impracticable to relate his duties as a banker in relation to sexual offenses. It's very difficult, sir. Thank you, Mr. Chairman. Thank you, Mr. Chairman. I'm inclined to go with. I am inclined to go with Senator Nala to the extent that the proposal must be germane. It must be germane to what we are considering. And we are considering the qualification of somebody who will serve as a director or a managing director, what have you, in a bank. So to the extent that we will consider that proposal, that conviction must necessarily derive from his employment. If he's convicted for a sexual offense, it has to arise from the work environment. It must be germane. It must be germane to the position he's seeking in the bank at that particular time. So it's not just enough that he's been convicted for a sexual offense. There must be probably somewhere else where we can bring that, but for sure, not under this provision. Thank you, Mr. Chairman. Just to buttress the point, I am inclined to support supporting the position taken by my learned friend. My only addition is that this is law that we are enacting, and we will leave it for people to interpret. And during interpretation, we don't want people to have problems in interpreting the law, because there is the etiam generis rule, where some other things that are not added, you can apply those things. But where you want to apply something and the thing does not fall in line with what is provided for, then it becomes a problem for those who will have the responsibility of interpreting the law. So, Mr. Chairman, the position taken, if for any reason you want to include that one, it's not this one. Maybe in another provision, not this one. Thank you, Mr. Chairman.
My distinguished colleagues, let's vote on this, please. I think we have listened to the two sides of the argument. So I will put the question. Because this is not supposed to be second reading. We are considering a report. So those in favor of clause 47, that it stands part of the bill as it is, say aye. Those against it, say nay. The ayes have it. Clause 48. Clause 48. 48 is on page 109. Those in favor that clause 48 stands part of the bill, say aye. Those against, say nay. The ayes have it. Clause 49. Clause 49. Those in favor that clause 49 stands part of the bill, say aye. Those against, say nay. The ayes have it. Clause 50. Those in favor that clause 50 stands part of the bill, say aye. Those against, say nay. The ayes have it. Clause 51 on page 102. Clause 51. Those in favor that Clause 51 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 52 on page 113. Those in favor that Clause 52 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 53. Those in favor that Clause 53 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 54 on page 114. Those in favor that Clause 54 stands part of the bill say aye. Those against say nay, the ayes have it. 55 on page 116. Those in favor that Clause 55 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 56. Clause 56. Those in favor that Clause 56 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 57 on page 118. Clause 57. Yeah, 57, Senator Johnson.
Because that particular provision is very sensitive, considering the type of society we live in, I just want us to be very careful, and perhaps for the chairman of the committee to explain, for us to understand what that provision is all about, because of the type of society we live in. Thank you, Mr. Chairman.
Can you give us a clarification on Clause 57 on page 118? Prohibition of unlicensed financial institutions.
Clause 157. Is it 58 or 57?
58.
Okay. Right?
57. On page 118.
Okay, I have my own.
118.
Page what? Page 118. I have two major issues. Calm down.
Clause 57. Those in favor that Clause 57 stands part of the bill say aye. Those against say nay, the ayes have it. 58 on page 120. Clause 58. Those in favor that Clause 58 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 59 on page 122. 59. Those in favor that Clause 59 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 60 on page 123. Clause 60. Those in favor that Clause 60 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 61. Those in favor that Clause 61 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 62. Those in favor that Clause 62 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 63 on page 127. Clause 63. Those in favor that Clause 63 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 64. Clause 64. Those in favor that clause 64 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 65 on page 132. 65. Those in favor that clause 65 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 66. Those in favor that clause 66 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 67. Those in favor that clause 67 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 68 on page 136. Clause 68 on page 136. Those in favor that clause 68 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 69, standard for payment. Those in favor that clause 69 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 70 on page 137. Those in favor that clause 70 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 71. Those in favor that clause 71 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 72. Unclaimed funds. 72. Those in favor that clause 72 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 73. Clause 73 on page 142. Clause 73. Those in favor that clause 73 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 74. Those in favor that clause 74 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 75. Those in favor that clause 75 stands part of the bill say aye. Those against say nay, the ayes have it. Yes, DSP.
To bring you back to 140. 140, that's section 72.3. 72.3. The way an account which is transferred under subsection 2 of this section is subject to a service charge, the charge may continue to be levied up to the date on which the account was transferred to the register of dormant accounts. I take that back. I was thinking that even when dormant, they were still going to be charging. I take that back. Thank you.
We'll go to clause 76. Those in favor that clause 76 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 77, levy on banks, page 148. Those in favor that clause 77 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 78. Clause 78. Those in favor that clause 78 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 79 on page 150. Those in favor that clause 79 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 80. Those in favor that clause 80 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 81. 81. Deputy Chief Whip.
Thank you, Mr. Chairman, distinguished colleagues. Ali Sabi of the line. Clause 81, continuing at page 151, that is subsection A, where it said two representatives of the bank to be nominated by the governor, one of whom shall be a deputy governor, who shall be, B is missing, appointed as the chairman of the board of trustees. B is missing.
Those in favor that clause 81 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 82. Those in favor that clause 82 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 83 on page 152. Those in favor that clause 83 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 84. 84. Deputy Minority Leader.
Or Secretariat of the Board of Trustees, that there is hereby established for the Board of Trustees a secretariat which shall be situated. D is missing.
It's legal. Well, it can be situated.
No, there shall be no B if it is a legal language. If it is situated, there shall be no BE there. It is either we remove BE or we add D.
We remove the BE.
Yes, we remove BE.
Those in favor of clause 84 as amended. Shall situate. We delete the B, the BE. Shall situate. Okay, it's a legal document. Those in favor of clause 84 as amended, that clause 84 stands part of the bill, say aye. Those against say nay, the ayes have. Clause 85. Those in favor that clause 85 remains part of the bill, say aye. Those against say nay, the ayes have. Clause 86. Those in favor that clause 86 stands part of the bill, say aye. Those against say nay, the ayes have. Clause 87. Those in favor that clause 87 remains part of the bill, say aye. Those against say nay, the ayes have. Clause 88 on page 156. Dissolution of resolution fund. Those in favor that clause 88 stands part of the bill, say aye. Those against say nay, the ayes have. Clause 89. Those in favor that clause 89 stands part of the bill, say aye. Those against say nay, the ayes have. Clause 90 on page 157. Those in favor that clause 90 stands part of the bill, say aye. Those against say nay, the ayes have. Clause 91, annual report. Those in favor that clause 91 stands part of the bill, say aye. Those against say nay, the ayes have. Clause 92. Those in favor that clause 92 stands part of the bill, say aye. Those against say nay, the ayes have. Clause 93. Those in favor that clause 93 stands part of the bill, say aye. Those against say nay, the ayes have. Clause 94 on page 160. Those in favor that clause 94 stands part of the bill, say aye. Those against say nay, the ayes have. Clause 95. Clause 95. Those in favor that clause 95 stands part of the bill, say aye. Those against say nay, the ayes have. Clause 96. Those in favor that clause 96 stands part of the bill, say aye. Those against say nay, the ayes have. Clause 97 on page 163. Those in favor that clause 97 stands part of the bill, say aye. Those against say nay, the ayes have. Clause 90. Clause 97. Those in favor that clause 97 stands part of the bill, say aye. Those against say nay, the ayes have it. Clause 98. Those in favor that clause 98 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 99. Those in favor that clause 99 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 100, power to grant exemptions, page 166. Those in favor that clause 100 remains part of the bill say aye. Those against say nay, the ayes have it. Clause 101. Those in favor that clause 101 remains part of the bill say aye. Those against say nay, the ayes have it. Clause 102. Those in favor that clause 102 remains part of the bill say aye. Those against say nay, the ayes have it. Clause 103. 103, DSP.
(103) to be amended thus. 103.1. The tribunal shall consist of not less than 10 persons to be appointed as full-time members by the President of the Federal Republic of Nigeria. Period. We should delete on the recommendation of the governor. And if I must provide a rationale, we have had so many situations where... Oh, okay. Thank you.
Let us explain the situation, sir. You need to explain the reason so that the members will be clear of the reasons why.
Thank you, Mr. Chairman. The reason I'm making this amendment is because for some time now, we have had ministers who have been conferred with identical powers in most of our extant laws, who have not turned themselves into de facto president, to the extent that even when a president makes an appointment, they will come and say that they were not the ones who made the recommendation to the president, and therefore that nomination, should not go forward. We are not in any way saying that Mr. President should not consult. He has the right to consult, but we should not write into the law that it is the minister or the governors in this case that must make the recommendation. But Mr. President is free to consult with the governor, before making the appointment. But we should not write that consultation into the law. See, he has a right to consult Mr. President, the governor, for recommendation, but we should not write that into the law. Because if we do that, and Mr. President decides to appoint you, for instance, and the governor of the CBN does not recommend you, he will say that you've not complied with the law. So that's why the reason for this amendment. Thank you very much.
Mr. President, my distinguished colleagues, I'm Kabir Ugaya from Kano South. I second the motion ably moved by the DSP on that section 1031 should be amended as he did. I so support.
Distinguished colleagues, those in favor of that clause 103 as amended stands part of the bill say aye. Those against say nay. The ayes have it. Huh? You want to amend? Let's ask the chairman first. Why 10? And then if we are not satisfied, we can go for amendment. Chairman.
Mr. President, I think there's nothing wrong in having 10 because there will be chairman of the tribunal, then there will be members. So the idea of whether they are 9 or 10, I don't think there's any difference. So that's why we agree on 10 as a committee.
But, distinguished colleagues, it reads, the tribunal shall consist of not less than 10. It can be 12, it can be 13, or even 19. So I think they can choose their odd number, not less than 10. I think we can leave it like that. Huh? Yeah, we can leave it like that. Okay. So we have already passed that. Clause 104. Clause 104. Those in favor that clause 104 stands part of the bill say aye. Those against any the ayes have it. Clause 105. Those in favor that clause 105 stands part of the bill say aye. Those against any the ayes have it. Clause 106. Those in favor that clause 106 stands part of the bill say aye. Those against any the ayes have it. Clause 107. Those in favor that clause 107 stands part of the bill say aye. Those against any the ayes have it. Clause 108. Those in favor that clause 108 stands part of the bill say aye. Those against any the ayes have it. Clause 109. Those 109. Okay, 108 DSP.
Mr. Chairman, I'm thinking that this would be the appropriate place to incorporate the amendment made by Senator Betty Apiafi the other time with respect to where a member shall cease to hold office. In addition to all of the provisions here on sound mind, bankruptcy, conviction of a felony, other offense involving fraud or dishonesty by the court, we should not include conviction for a sexual offense. Thank you. Thank you.
170. It's additional ground.
Those in favor that clause 108 stands part of, as amended, stands part of the bill say aye. Those against any the ayes have it. Clause 109. Those in favor that clause 109 stands part of the bill say aye. Those against any the ayes have it. Clause 110. Those in favor that clause 110 stands part of the bill say aye. Those against any the ayes have it. Clause 111. Those in favor that clause 111 stands part of the bill say aye. Those against any the ayes have it. Clause 112. Those in favor that clause 112 stands part of the bill say aye. Those against any the ayes have it. Clause 112. Those in favor that clause 112 stands part of the bill say aye. Those against any the ayes have it. Clause 113. Yes, Senator Peter Ngwabshi. So we'll go back to 111. Those in favor that clause 111 as amended stands part of the bill say aye. Those against any, the ayes have it. Secretary, take note. Clause 113. Those in favor that clause 113 stands part of the bill say aye. Those against any, the ayes have it. Clause 114. Those in favor that clause 114 stands part of the bill say aye. Those against any the ayes have it. Clause 115. 115. Those in favor that clause 115 stands part of the bill say aye. Those against any the ayes have it. Clause 116. Power to stay proceedings on page 176. Those in favor that clause 116 stands part of the bill say aye. Those against any the ayes have it. Clause 117. Those in favor that clause 117 stands part of the bill say aye. Those against any the ayes have it. Clause 118. Those in favor that Clause 118 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 119. Those in favor that Clause 119 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 120. Those in favor that Clause 120 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 121. Those in favor that Clause 121 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 122 on page 179. 122 on page 179. Those in favor that Clause 122 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 123. 123. Senator Yusuf.
123(2) and the next paragraph after 2. That provided that no person shall be appointed under such person unless such person possesses a minimum of 10 years experience in banking and credit operations. I want to add in credit operation and or capital market. In credit and or capital market operations. Yes. In banking and credit or capital market operations.
Mr. President, distinguished colleague, I want to second that amendment as moved.
So why are you laughing? Those in favor that Clause 123 as amended stands part of the bill say aye. Those against say nay. The ayes have it. Clause 124. Those in favor that Clause 124 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 125. Those in favor that Clause 125 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 126. Those in favor that Clause 126 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 127 on page 185. Those in favor that Clause 127 stands part of the bill say aye. Those against say nay. The ayes have it. Clause 128. Those in favor that Clause 128 stands part of the bill say aye. Those against say nay. The ayes have it. Senator Bala Ibn Allah.
Sorry to take you a bit back on 126, sir, Clause 126. Again, it appears to be a constitutional issue, sir, in the sense that the Constitution has already defined what a superior court of record is. And the intendment of the Constitution is to confer specific powers to this court. So I'm in difficulty to understand how we can, by law, confer those powers on a court created by law. It's an anomaly, sir. I don't know how we can really save this section 126.1. 126.1.
Any okay, so how do you want it? He originated. How do you want it? Senator Balanala, how do you want it? If you are objecting to the way it is.
Yeah, I'm in difficulty to recount it because I'm trying to again be very careful. See, sir, the powers conferred on Superior Court of Record under the Constitution are definite. And the Constitution itself has recognized those courts that can be called Superior Courts of Record. Now, What this provision seeks to do is to confer the inherent powers of those. Yeah? Yeah. Yes.
It's in normal court. In normal court. Remove the normal court.
Huh? Yes, you can follow the new account.
Okay, we go back to 126, clause 126. Those in favor that clause 126 as amended stands part of the bill say aye. Those against any, the ayes have it. Clause 128, we have done with 87. Those in favor that clause 128 stands part of the bill say aye. Those against any, the ayes have it. Clause 129 on page 186. Those in favor that clause 129 stands part of the bill say aye. Those against any, the ayes have it. Clause 130. Those in favor that clause 130 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 131. Clause 131. Those in favor that clause 131 stands part of the bill say aye. Those against say nay, the ayes have it. Clause 132. Those in favor that clause 132 stands part of the bill say aye. Those against say nay, the ayes have it. Explanatory memorandum. Those in favor that the explanatory memorandum stands part of the bill say aye. Those against say nay, the ayes have it. The short title. Those in favor that the short title stands part of the bill say aye. Those against say nay, the ayes have it. The long title. On page 1, those in favor that the long title stands part of the bill say aye. Those against say nay, the ayes have it. Leader of the Senate.
Mr. Chairman, I'm extremely sorry, but it's important in overriding public interest that I seek your indulgence to take us back to clause 103. It is very, very, very important, Mr. Chairman. Clause 103, Mr. Chairman. It's on page 167. Mr. Chairman, this is crucial. Page 167. Mr. Chairman, it's at your discretion.
Well, this is where we'll round off today's live broadcast of Senate plenary. Well, the Senate has considered the executive communication from President Muhammadu Buhari that came to the floor yesterday, introduced it on the floor, and then referred it to the Senate Committee on Finance and Appropriation for consideration. While the executive communication for the confirmation of the nomination of Dr. Chukwuemeka Chukwu for appointment as Resident Electoral Commissioner for the Independent National Electoral Commission has also been referred to the Senate Committee on INEC. Well, at the moment, Senate has been considering the amendment bill for the banks and financial institutions. That bill is still ongoing. That bill, well, however, seeks to update laws governing all financial institutions and their services. The bill also converses the creation of a special tribunal of not more than 10 persons for the enforcement and recovery of eligible loans and fast resolution of financial-related cases. Well, at this point in time, we will now hand you over to our studios to follow our remaining programs for the day. Enjoy the rest of our programs. Bye for now. I am Ignatius.
They will have majority of people who will do what they want them to do. No law can really, pass good governance tests or best practice standard, in this form. It should be not more than instead of not less than. Yes.
Well, I'm not a lawyer.